Small claims. This is part of an informational video series produced by CHS. This video is intended for informational and learning purposes only and shall not be construed as legal advice. CHS is not liable for any misuse of information contained herein. What is small claims court? Small claims court is a place where you can sue a person or business if the amount you are seeking is $10,000 or less. The case may be based on a broken agreement or that someone has harmed you or damaged your property. When can you use small claims court? The following are some examples of small claims cases when $10,000 or less is claimed. Someone physically injures you or damages your property and refuses to pay for your loss. Your landlord refuses to return your security deposit. Someone owes you money for work you have done but refuses to pay you. You have paid for work to be done, but the work was done poorly and the contractor refuses to fix it. The following are some examples of cases that cannot be filed in a small claims court, and they include criminal cases, evictions, foreclosures, family cases, injunctions, also known as court orders, civil cases seeking more than $10,000, all cases asking for something other than money. It is important to understand that small claims court can order a judgment only for money. It cannot require a person or a business to do something, to stop doing something, or to return property. What should I consider before filing a small claims case? Before filing a claim, try contacting the other person or business to solve the problem out of court by coming to an agreement or a settlement. Call or write the other party to explain your position and the settlement you want. If successful, you will save money, time, and effort. Consider whether the defendant has money, income, or property. If they do not, you may not be able to collect even though a judgment has been entered. Who can file a small claims case? Persons who are 18 years of age or older may file a small claims case with or without a lawyer. Regardless of your choice, your opponent has a right to appear through a lawyer. Persons under 18 must have a lawyer. A corporation can also file a small claims case, however, they must be represented by a lawyer. Persons and businesses must sue and be sued in their correct legal name. You cannot collect money against a defendant who is incorrectly named on the small claims complaint. Before filing your lawsuit, check for the correct spelling, address, and phone number of the defendant. If you sue an incorporated business, you must use its legal name, which may be different from the name you know it by. You can find out if a business is a corporation and obtain its legal name by searching for a company's certificate of good standing at the website on the screen. If you intend to sue an unincorporated business, a sole proprietorship, or a general partnership, you should name the owner of the business itself as the defendant, along with the abbreviation D/B/A, meaning doing business as. You can see the example on the screen. If the unincorporated business operates under an assumed name, an advertising name, such as Action Plumbing, you may be able to find out the name of the owner, whom you must name as the defendant, by consulting the county clerk or the local municipality. Remember, a judgment against a defendant who is incorrectly named cannot be collected. Where do I file the small claims complaint? Generally, you must file your small claims action in the county where the defendant lives or where the events of the case happened. For example, where the accident occurred or where the contract was signed. A business may be sued in any county where it does business or has an office. You can find out their locations by visiting the business's website or by calling them. If you file your claim in the wrong county, it may result in the judge throwing out your case, dismissing your case, or possibly being transferred to the correct courthouse. If you're not sure which county is right, consult a lawyer. All the forms that need to be filled out you can find at the link posted on the screen. You will be able to click and download each form. At the website, make sure that the top banner says Circuit Court Forms. Find and click on the Small Claims Complaint form and, if needed, the fee waiver for civil cases. There are many forms that need to be filled out. These include the Small Claims Complaint, the Small Claims Summons, and letter to the sheriff if needed. We will explain each of these in a moment. You can download each form and fill it out to submit online. You will need access to Adobe to be able to fill in and save. The Small Claims Complaint form asks the court for a money judgment and gives the information to begin the case. The form will ask for your email address if you have one and a mailing address. This is where important legal documents will be sent to you. We suggest you use an email account that you do not share with anyone else and that you also check every day. If you do not check your email and your regular mail every day, you may miss important information, notices of court dates, and other important documents from all parties. And you don't want to neglect any of those. The small claims summons is the form that tells each defendant that you are asking the court for a money judgment. The letter to the sheriff is a form that should be used when suing a defendant and opting to ask the sheriff to notify them of your small claims complaint. The application for waiver of court fees is only needed if you cannot pay the filing fee. You file the application for waiver of court fees to ask the court to file at a reduced cost or for free. What do I do after I fill out the forms? First, file your forms with the circuit clerk. Second, serve the defendant. And third, request a court date. First, you must file the small claims complaint and the small claims summons with the circuit clerk. You must electronically file, e-file, your court documents unless 1. You are an inmate in a prison or jail and do not have a lawyer, 2. Have a disability that prevents you from e-filing, or you have another qualifying exemption. Next, you serve the defendant, the person you are suing, by delivering copies of your small claims complaint and small claims summons. If you are suing more than one person, you must serve every person that you are suing. You can serve each defendant in one of 3 ways: through the circuit clerk, through the sheriff, or through a special process server. Finally, you will have to get your court date. You will ask the circuit clerk if you have to schedule a court date or if one will be scheduled automatically. You will need to schedule the court date. If you need to schedule the court date, ask the circuit clerk how to do so. The circuit clerk may schedule the court date, or you may have to speak with other court staff. When you get your court date, ask the court if the court will send notice to the court date to the other party or if you need to. The Illinois Supreme Court has ruled that the court date must be between 40 and 61 days after the issuance of the summons. How do I prepare for my case for trial? First, you want to confirm service. The day before the court date, contact the circuit clerk's office, the sheriff's office, or other persons authorized to serve the process to determine if your small claims complaint and summons were served to the defendant. To get ready for your court date, if your court date is by video phone, make sure you have the call-in or login information for your court date and make sure your technology is working. Follow the instructions on the court notice that you received. Call the circuit clerk or visit their website for specific technology instructions. Bring the following items with you to court: copies of all documents you filed with the circuit clerk, any documents you want the judge to look at, a photo ID, and please bring any witnesses you want to testify. If your court case is in person, arrive at the courthouse at least 30 minutes early. Go to the courtroom number listed on your court form. If your form does not have a courtroom number, look at the list of cases at the courthouse or ask the circuit clerk for help. Check in with the courtroom staff and wait for your name and case number to be called. When your case is called, walk up to the judge and introduce yourself. When you present your case, you, as the plaintiff, will present your case first. To present your case, tell the judge the facts and details of the case. Give any evidence, such as paperwork or photos, to the judge. If you brought witnesses, ask the judge to bring up your witnesses. Ask witnesses questions about the case so the judge can hear their answers. After each witness testifies, the defendant can question witnesses, including you. When presenting your case, be brief and stick to the facts. State what happened in the order it happened. Do not interrupt or argue with witnesses. Listen carefully so you can tell the judge why you disagree when it's your turn to speak. After you finish presenting your case, the defendant will present their case. The defendant may testify, ask questions of witnesses, and present physical evidence. You may question each of the defendant's witnesses, including the defendant. If the judge asks you questions, answer them clearly and directly. After hearing both sides, the judge will make a judgment and write it in the small claims order or their own order. Get a copy of the order before you leave the courtroom. The judge may award you all or part of the money claimed, or the judge may find that the defendant does not owe you any money. Afterwards, you may leave. After the small claims order is entered, if you win the case, the defendant owes you the amount on the order. If you lose, you have two options. You can file a motion for the judge to reconsider the ruling or file an appeal to a higher court. Either option must happen within 30 days. CHS, the Community Outreach and Advocacy Program, is here to help. Contact us anytime through email, text, or video phone at our information on the screen.